Hi, this is Jim Cunningham. We're going to talk about 5 ways to put assets inside a living trust, aka funding your trust. Now, lawyers use a lot of legal terms. Funding means putting assets in the trust, and we'll explain very briefly what a living trust is and what we're talking about here, right? So, only after you create this trust, which is a document, it's a written document signed, typically acknowledged before a notary public, also known as notarization, which isn't a real word, acknowledged before notary public. But if you have a living trust, you got to put assets in the trust. So it can only be funded after it's created, and they are not typically immediately funded when you sign that document. So a will, when you sign a will, you're done. You sign it, that's it. With a living trust, you have to take additional steps after that. It is kind of like a super will. And so you really do have to pay attention to your funding of the trust. Now, some assets is very important to understand. Some assets do not go into a living trust, should not go into a living trust, and we'll kind of unpack the why on that. I'm a partner at Cunningham Legal. I have over 25 years experience. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust, and probate law, a real estate broker, securities insurance licensed, and a pilot. These are the lawyers in our law firm. So my 2 partners, Rochelle and Tasha, and the other attorneys in our firm, a great group of people. If you're watching this on YouTube, go ahead and click subscribe and click the little bell, and you'll be alerted to when we release content on YouTube, which is typically Thursday at about 6 p.m. So if you're watching this and you're like, Jim, you talk too fast, or I need to see this again, it's going to be on YouTube at about 6 o'clock this evening. Disclaimer, I'm a lawyer. I'm talking. My lips are moving. This is absolutely not legal advice. So when I say you, there is no attorney-client relationship, okay? So it's a lot like Shark Tank. When you watch Shark Tank, no one's offering you any money. You're watching a TV show, so you're watching a video. This is not legal advice. So what is a living trust and what is a successor or future trustee? Because this is something very important to understand. A living trust is basically a container. It's a bucket. It's a bucket with a handle, and the trustee holds onto the handle. A trust has to have 3 things. It has to have a trustee, it has to have a trust corpus, and it must have a beneficiary. Now, if you are setting up a living trust, you set up this bucket, you're going to put your house, your stocks, your bonds, your mutual funds in there. You're going to hold on to that handle. You're the trustee of your living trust typically, and you're the beneficiary. And why do we do this? We do this simply to avoid probate and maintain privacy. It's very important to understand that a living trust is created for the benefit of the beneficiaries. This is hardwired into Anglo-American law, right? Throughout the United States and in the English-speaking countries that have trusts. Trusts are for the benefit of beneficiaries. Probate is for the benefit of your creditors. And a lot of people don't understand that there's the subtle nuances. There are different creditor claims procedures after somebody passes away. So probate, significantly more creditor friendly. A living trust, significantly more beneficiary friendly. And I don't know about you, but I'd rather have my assets go into my family rather than having to go through hoops to check in with my creditors to make sure they're paid off. So when you stop being trustee, that bucket, so you're holding on to the handle as trustee. When you stop being trustee, that bucket doesn't go away, right? Just because you don't have the handle anymore, that bucket is then transferred to the successor trustee. Now, the term successor trustee can be confusing. You're the trustee while you're alive. Your successor trustee is somebody who will serve in the future, potentially, right? This person will serve in the future, but they're not serving now. So successor trustee means future trustee, and it's really important to pay attention to the language that lawyers use, because if you hear the term successor trustee, typically it means someone who's not serving right now. So trustees are always trustees, successor trustees are future trustees, and living trust, again, much better than probating a will. Funding your trust. The first thing we're going to talk about is real estate. And so I hear we have some real estate professionals watching this. We have a lot of people reserved or signed up for this webinar, which is great. And if you're watching this on YouTube, please share this with your friends. This, I would say, is probably the single most critical asset. If I could just pick the most important asset for the vast majority of our clients, it is making sure that the real estate gets into the trust. So you fund your trust. If you bought your real estate, your home, your commercial property, your multifamily, if you bought that before you created your trust and you create your trust, how do you get that into your trust? Well, you do it by deed. So in California and throughout the United States, real estate is transferred by deed. What that means is it is a piece of paper, right? Now, sometimes you can do these documents electronically, but it is a piece of paper that is notarized or acknowledged before a notary public, signed and delivered to the recorded at the county recorder's office. So how do you go about doing this? Well, look at your deed. If you don't have your deed, look at your property tax bill. Your property tax bill frequently has the name. Don't go online and get it because they won't give you the information online. You got to look at the one that they actually mail to you. That typically has a name on it. Look at the name. If it's in your trust, if it's your trust name, it's in your trust. If it's in your name, it's probably not in your trust. So how do you get it in your trust? Call an estate planning lawyer. So you typically want to go to the estate planning lawyer. It's very important to have some certain specific language on there. Otherwise, it could be problematic for your successor trustee, right? Your future trustee. Attorneys typically prepare the deed. The deed is then notarized or acknowledged before notary public, and then we, our office, we handle that. So if this is you, if you say, yeah, I set up this trust and I don't have this piece of property in my trust, I need some help with that, give us a call, reach out to us, and we can certainly help you with that. So there are different type of living trusts. Types of living trusts. We have revocable trusts, we have irrevocable trusts, and land trusts. We don't really see those too often. And when you acquire the property, if you already have a trust, you can have the name of the trustee and the trust, and we'll have an example on that in a couple of slides. And then this is very important to understand. If you are buying property and you have a living trust, if you're buying property, you're not signing the deed. The person who's selling you or your trust the property is signing the deed. So if you own the property, you get that property in your living trust by you signing a deed. If you're buying a new property and have a living trust, you can take title in the name of the trust directly without having to go through that extra step of another deed. So there are two types of deeds. There's a grant deed and a quitclaim deed. So a grant deed comes with some warranties of title. Basically, if I'm granting property to somebody, I define what I am conveying, right? So I am conveying an undivided 100% interest in Greenacre. I'm conveying that to Abel, right? So Jim to Abel, that's a grant deed. I grant that to Abel. Now, there's also this after acquired property issue. Sometimes if you acquire property later, that automatically transfers. If you have some interest that pops up, it automatically transfers to the transferee. So a grant deed, a lot of times we're going to use those in the estate planning situation. We tend not to use quitclaim deeds for estate planning to fund your trust. And so a quitclaim deed, it comes from the French quitter, which means to give, right, or transfer, or to leave. So a quitclaim deed says, I am quit. It is not a quick deed, like quick, like rapid. It's not a quick deed. It is a quitclaim deed. And this deed says, whatever I own, whatever I happen to own, I might own, whatever I might not own, right? I am conveying that to Abel, for example. So Greenacre, I signed a quitclaim deed. How will Abel know that he's getting anything? Anyone can sign a quitclaim deed, right? I could sign a quitclaim deed on the White House. I don't own the White House. I guess, as a citizen, it's the people's house, but I don't own it. The federal government owns it, right? So this is really important. So when you're going through like a title search, a quitclaim deed, we give those different weighting than a grant deed. So if a person comes into our office and they say, I acquired this property through a quitclaim deed, we're going to have to do a little bit of digging because we're not really sure necessarily what this person got, because typically you're not 100% sure. There are no implied warranties, and these are often used in divorce proceedings to perfect title. They're frequently seen when spouses are financing property. Maybe if a spouse is taking title in his or her name as sole and separate property, you might see a quitclaim deed from the spouse. So they do have their limited use, but we typically don't use a quitclaim deed in the estate planning context. We're using a grant deed. So so just a point of confusion, whoever came up with deeds of trust is very confusing to the layperson, the non-lawyer or the non-real estate professional. Don't use a trust deed or a deed of trust. This is a mortgage document, okay? Deeds of trust do not convey equitable title. So they deal with legal title. They deal with who has the right to control the property, not who owns the equity, hence equitable title, who actually owns the underlying property. So it's used for a non-judicial foreclosure. If you do not make your mortgage payment, they're going to warn you. And then somebody takes legal title. Typically, it's a title insurance company. They name themselves. They take legal title as trustee, and then they'll sell that property on the courthouse steps without having to go through a lawsuit to foreclose on the property. So it's a lot like a mortgage. You can think of it as a mortgage. This is not something you would do to convey title to property. Now, if you hold a deed of trust, maybe you lent somebody money and you hold the deed of trust, we execute an assignment of your deed of trust from you to your living trust. So it's an assignment. It's not a deed. It's a slightly different format. So very important. If you're the lender, obviously it's an asset. You're going to want to deal with that, but don't use that for trying to convey title. All right. So if you have a living trust, buying property with a living trust, you need to make sure that the trust gives you permission, gives a trustee permission to buy real estate. So one thing to understand about a trust has a trustee, and there's also a written document. Now, in certain contexts, there's no written document that would be called a constructive trust, something totally different. What we're talking here is written documents. So a trustee only has the powers enumerated in the document. So if you have a living trust and it says nothing about being able to own real estate, arguably the trustee can't deal with real estate. Now, do we see this in the real world? No. Do we see it with homemade living trust? Maybe somebody got a form off the internet and said, this 80 pages is way too long. I'm going to cut this thing down to 3. I'm going to cut out all that unnecessary language. Well, yeah, you might need that language if you want to own real estate. So you direct the title company. So when you take title, if you buy a piece of property, and my wife and I bought a property a couple of years ago, and they gave us 9 options as a married couple, 9 options to pick, like how do you want to take title to your property? And I really had to think about that. And I'm like, I do this every day. And I had to look at it and really kind of go through. I can't imagine just a normal person who doesn't have background on this. Like, what do you pick? So if it's your trust, the example we give here is John Smith, trustee or successor trustee of the Smith Living Trust, dated September 14, 2023, which happens to be today, the day of our recording, and any amendments there too. So it's not enough to name the trust. You name the person who is trustee. And it's very important here, and this is why we started with the difference between trustee and successor trustee. It is best practices to put the term successor trustee in there, because John is going to be dead one day, right? We all die. And this trust will still be around. And so somebody else, maybe Jane Smith steps in to handle the trust administration and deal with those assets. You name the trust. Trusts typically have a date, not all, but it's best. Again, you should. It's kind of like, washing your hands before you eat or brushing your teeth before bed. These are things that you should do that don't always happen. But the name of the trustee, the John Smith, trustee or successor trustee, the Smith Trust, with the date of the trust. And this is really critical, and any amendments there too, because a living trust is amendable. It's revocable. So you can change it. So if it just says John Smith, trustee or successor trustee of the Smith Living Trust, dated September 14, 2023, with a period, there may be a question as, is this property, right, subject to those subsequent amendments? And do people litigate this? Yeah. I mean, if the facts are there. So it's very important to have a correct format. And I would say this is best practice, is the best format. The seller. So again, the seller is kind of funding your trust, which is kind of weird. It's Captain Obvious stuff, but the seller signs the deed, conveys title to John Smith as trustee. And typically the deed is recorded by the title company at your local friendly county recorder. Let's move on to funding your trust, bank and brokerage accounts. So bank accounts, you pretty much have to go to the bank. So you take your trust, you take your ours come in a binder with tabs, because there are a lot of documents in there. And there's not just a trust, there's a will, there's durable power of attorney for property. We'll talk about that in a little bit. Healthcare documents, a lot of stuff in there. And what you need to do is identify your accounts. Now, you're not going to put in IRA accounts. So if you have an IRA account at a bank, and we'll talk about brokerage accounts in a couple of slides. If you have IRA accounts, we're not putting those in. We're going to talk about that. We're talking about accounts that are in your name, not IRA, 401k, 403b, TSA, those type of accounts. Contact the bank, reach out to them. How do I fund this trust? Do I have to go to a specific branch? Do I have to make an appointment? Whatever it is, they will have forms that you complete. You're probably going to have to do a new signature card. You may have to open up a new account for that trust, or they may be able to change the name of the account and you use your own taxpayer and use your own social security number as a taxpayer identification number for the trust. So you got to figure out which accounts, and you can work with your lawyer. And if you're a client of ours or a future client, then we can go over with you, and we actually give you letters that you can take to the bank. That's part of our service offering. And it kind of identifies the account and gives the bank instructions. So you just kind of walk in and hand them the documents, but then the bank typically will help you complete the forms. And then the bank then changes the ownership, and then you need to review your statements. So if you do get your statements electronically or by mail, look at them and hey, is the name of my trust on here, or is it still my name? Okay. And then you got to rinse and repeat on for all your other accounts at all your various institutions. Brokerage accounts are similar. And I have a separate slide because a lot of brokerage accounts have what's called a household account. And this, again, can be kind of confusing for people who are not in this industry or this profession. A household account might have your IRA, might have a 401k, it might have a 529, it might have an annuity, right? It might have stocks and bonds, like a whole bunch of different things. So what we're talking about, and this is why you want to work with your financial advisor, is you want to make sure that your IRAs don't go into your living trust, and we'll explain why in a couple of slides. But you want to make sure that those brokerage accounts, if in meeting with your lawyer, and if it's with us, these are conversations that we have about funding your trust. Should these accounts be in this particular living trust? Yes or no? We identify those accounts, and then we facilitate the contact with your advisor. Now, if you're working with one of our advisors on our A team, or if you have this sort of A team that we talk about in other webinars and other videos, that happens to go pretty fast, it can get a little clunky if you're trying to do this on your own or don't really have a good relationship. Complete the required forms. Again, you're going to have forms. It's going to be like your bank accounts. And then the institution changes the ownership. And then you're going to get the statements. Very important. You need to look at those statements. Does the name of your trust appear on there? That's how you're verifying if your trust is funded. And then you, again, rinse and repeat. Do this for if you have more than one relationship or more than one brokerage account. But these, I would say, banks and brokerage accounts, I started practicing law 30 years ago doing estate planning. And it was just a pain. No one knew how to do anything. Now they're very familiar with trusts. Business interests. So very important to make sure you pay attention to funding your trust if you have any business interests. So partnerships and LLCs, slightly different than corporations. We'll talk about that in the next slide. Transferring your partnership or LLC interest is fairly, easy. It's not a big deal if there are no additional requirements in the business agreement. So a partnership will have a partnership agreement. An LLC typically will have an operating agreement, although it's not required. Actually, on a partnership, you're not even required to have a partnership agreement, but you probably should, right? You need to have some evidence that this partnership interest or LLC interest is transferred to your trust. So we do an assignment of interest. So it's a document that says, I own these shares in the LLC, and I'm transferring these shares to my living trust. And then your manager updates your schedule of members, typically in an LLC, and may update your partner schedule on your partnership. So that's documented, and with those the managers of the partnership and the LLC, because they're also going to have to do tax compliance, right? So that will be one of the members, because partnerships and LLCs that aren't taxed as corporations, if they're disregarded entities or partnerships, they're passed through. They're not paying any tax. So that's passed through to the individual members. It's very important to review these agreements. Sometimes there are transfer restrictions. Many times there is an exemption for a living trust. So many times, if you have two partners and you have this operating business and you want to transfer your interest to your living trust, that's completely different than you selling your 1/3 interest to some stranger, and now they're partners with some stranger. So really important to pay attention to the language, but there typically is a carve out for a living trust. Pretty straightforward. Now, once a person passes away, it's a different story, right? Because if you have 3 partners in an entity and that partner passes away, you should have a buy-sell. You should have some succession language in there about who can become a partner. Does the spouse become a partner? Do the kids become partners with the other 2 partners? Interesting question. So we need to have that well thought out and documented. So corporations, corporate stock is transferred slightly differently. So we need to look at your corporate records. You have your ownership is typically a share certificate or a stock certificate. You endorse that on the back. You assign that through a stock power and then cancel the current certificates and issue new certificates in the name of the trust. So slightly more formalistic, slightly more legalistic. This is how you do it with a corporation. And if it's a publicly traded company, it doesn't matter, right? You would do this. You might have to get a medallion guarantee. But for those clients who still have shares of stock, we really encourage them to get a street account and have those held by a financial advisor, because oftentimes those are lost. If you lose your stock certificate, then you have to pay a premium of, I believe it's 3%, to have that stock certificate reissued. So we had a case many years ago. It was $1 million in stock. They lost the certificate. It was $30,000 was the fee to get a new certificate. So don't just be careful with those certificates. Personal property. Personal property. This is your stuff. Okay. Now, personal property, if it's tangible personal property, okay, that sometimes has a title. Vehicles, airplanes, boats, they have titles. If your boat's registered through the state, it's through the state. If it's a federal registry, it's through the United States government. So these have titles. Okay. Many of these assets, these can be actually quite valuable, the tangible personal property. What about stuff that doesn't have a title? Okay. What do we do with the stuff that doesn't have a title? Well, we have a personal property memorandum. Typically, we have a document that says I transfer all my personal property to my living trust. And then in our estate plan, this is sort of a mock-up, is we have this document, and it's a personal property memorandum. I say I give to my son my guitars. I give my daughters, my wife might say I give my daughters a jewelry. Sorry, son. Maybe I give my watch to my son. These are the type of things that don't have a title. And then we say who gets those in this personal property memorandum. This is really the only place you can write on your estate plan. And this is something that people will look at after you pass away. So your successor trustee will look at this, and they're in the trust. It says from time to time, I may make a writing, and that's in this binder, right? From time to time, I may make a writing that says I give whatever personal property to whomever I want. This is a great way to make a gift of personal property without having to list all those items of personal property in your trust, because, you have to pay a lawyer to amend that. And, who wants to pay a lawyer a bunch of fees to amend, kind of sentimental stuff? And that's why we use this personal property memorandum. And you can write it in and then scratch it out and initial it. We don't really see a lot of conflict with this. That being said, if it is personal property of significant value, art, collectibles, you may want to put that in your living trust. And if you don't have an assignment of personal property to your trust, then those are potentially a probate asset. And then that's where you have your what is called a pour-over will. It's also called a pour-over trust. So you have your living trust, which is this bucket with the handle. And then you have a will that says, if I have anything in my name when I die, I leave it to my living trust. It's very important to have that. So if you have a living trust, if you have a well-crafted living trust, you should have a pour-over will with it, also called a pour-over trust, even though it's a will. Now, our fifth, and we'll have some more after this. We have some little bonus material after this. Timeshares. This is a frequent question. So timeshares, you can own like points, and there's some registry at a company, or they can be deeded where you have, a 1/52nd right to occupy the property, right? I get to go to my condo in Hawaii 1 week a year, and that's deeded. So that's kind of a fork in the road. If it's the assignment, if it's an agreement, then you assign your rights to that agreement to your living trust. Potentially, if it's a deed, you would have a deed of that property to your living trust. And on some timeshare agreements, you can designate a beneficiary, right? And then sometimes it's a successor owner. But not everyone might want a timeshare. I want you to think about it. If you have a timeshare, or maybe your parents have a timeshare, and you're like, I don't know that I want to go to the same place all the time. I don't know that I'm really going to use it. We have all these maintenance fees. You might want to check with the people that you want to leave this timeshare to in advance, or sell it, right? So if you're not using it and you say, well, no one's really using it, I'm not quite sure what to do with it. A lot of people do sell their timeshares because they don't want to necessarily have their heirs, right? The people who inherit under their living trust to be saddled with those maintenance fees. Funding your living trust. What you might not want to put in your living trust. Life insurance. Now, why is that? Life insurance is a contract. So what this says is, you pay the life insurance company $1,000, let's say, and when you die, whoever you name as beneficiary gets $100,000, right? That's life insurance is a contract. Whether you die next month or 30 years from now, it is simply a contract. You pay this money when you die. This person gets the life insurance. Now, the durable power of attorney. So when you have a living trust, again, which is this bucket with a handle that there's a successor trustee, if the life insurance is not owned by the trust, if the owner of the life insurance policy is not the trust, then you deal with the policy through the durable power of attorney. The durable power of attorney has agency authority. So a trustee, you remember I mentioned that a trustee can only has the powers enumerated in the trust. An agent under a durable power of attorney, in most broad general durable powers of attorney, literally steps into the shoes of the person who created this power of attorney. So that person can do a lot of times everything that that individual can do who designated. Now, you're saying, why would I ever want to do this? Well, if you have a stroke and you can't, you're incapacitated, and we're going to talk about that on next week's webinar. What happens if you become incapacitated and you need to deal with the life insurance company for whatever reason? You do that with the durable power of attorney, and your agent under the durable power of attorney handles that, not your trustee. So why do we keep life insurance out of a living trust? Well, basically, that's kind of what the life insurance industry wants people to do. They want to have an individual owner. Now, there is an exception for an irrevocable life insurance trust. We're going to talk about that. But life insurance policies also have a beneficiary designation. So if I pay $1,000 to a life insurance company and nothing happens till I die, really the beneficiary can come in and get that money. Should the beneficiary be the living trust? Interesting question. Well, if the beneficiary is the living trust, remember I said that living trusts are hardwired. They're created for the benefit of beneficiaries. Probate is created for creditors. Creditors can still come after assets in my living trust when I pass away. There is a method to do it. It's a little more cumbersome and burdensome, but if I leave that life insurance to my living trust, that now is an asset that the creditors of my estate can go after. So let's say I'm driving a car and I get in an accident and it's my fault and I'm killed. Well, I might want to leave that $100,000 to my wife, because I think you have a better argument that, well, she wasn't driving the car, right? Now, there may be some other arguments why she's liable, but if she gets that money directly, it's not flowing through the trust, right? So you may want to you can also stack the beneficiary designation. So maybe the first beneficiary is the spouse, then the next beneficiary is maybe the living trust, and then maybe the third beneficiary are the children, so that the spouse can, what is called disclaim. So if the spouse says, look, there's no creditor issues, nothing's going on, I'm going to disclaim, and then that insurance proceeds then goes to the living trust. It may be that your spouse is incapacitated, right, and can't fill out a form. Well, then that your spouse's agent under your spouse's durable power of attorney would want to potentially disclaim. So I know it's getting a little complicated, but it's life insurance we treat differently than bank accounts and brokerage accounts and real estate. So if your estate is over in 2023, estates over 12.92 million are subject to 40% death tax. That's getting cut in half in 2026, by the way, January 1, 2026. That 12.92 million, we think will probably cut down to 7. It's kind of indexed to inflation, but it's worth looking at. If you have assets over 7 million, look at putting your life insurance in a life insurance trust, because it stays outside of your taxable estate. It's very, very important. So remember, life insurance is not taxable as income, but it is taxable. It's included in the total value of your estate. Again, if life insurance goes to your living trust, it's subject to your creditors. And some alternative ownership structures for instead of having the life insurance owned by the living trust, an irrevocable life insurance trust. Now, we have this in some of our other materials on our YouTube page. So if you just kind of check it out. But the idea here with the life insurance trust is that that insurance policy is owned by a trust that is not a living trust. It has very different provisions, right? It's kind of like saying, a car and a boat or something. I mean, they're really different. Okay. Different purposes. Outright distributions, right? Maybe to the spouse. And again, the tiered beneficiary designations with use of disclaimers. So again, that's you can say, if let's say the spouse is liable for something, spouse says, well, I don't want that. Have it go to living trust. I say, well, that living trust isn't good. Maybe it should go to the kids, right? Or maybe the wife doesn't need the life insurance proceeds, doesn't want it in her estate, and it goes to the kids. So again, tiering the beneficiary designations is a slightly more nuanced approach, but I think in certain circumstances can be beneficial. And just to understand this, either people or trusts own the policies, not LLCs, partnerships, and corporations. Now, can an LLC own a policy of life insurance? Yes. But for our purposes here for estate planning, we're not using the LLC, partnership, and corporate structure to own the policy. It's either going to be individual ownership or it's going to be owned by the irrevocable life insurance trust. So Hal has a $15 million estate. And of that $15 million estate, $3 million is life insurance, and he's $12 million in other assets. So it's $15 million. If he dies and the exemption's $12,920,000, that's $832,000 in taxes. If Hal had placed that life insurance in a life insurance trust and lived 3 years, there's a 3-year rule on that from when you put the policy into the trust, or the trust buys the policy from the get-go, then there's no 3-year rule. That 3 million, this is very important, and please pay attention to this. That 3 million in that life insurance trust passes outside of Hal's estate. That saves his family $832,000 in taxes. So, yeah, are there some legal fees involved with that? Absolutely. But is it worth it to save $832,000 in tax? Yeah. And that's something that has to be paid 9 months after death. So by visiting with this, an attorney at our firm, any attorney in our firm would see this and they would say, wow, Hal, you may want to put that $3 million policy in a life insurance trust and save your family almost $1 million in taxes. Retirement accounts. Bonus material, folks, not advertised. Retirement accounts don't really play well with a living trust. These stay out of your living trust. So when you think of, you got your trust with the handle and you're the trustee and you put your house, your stocks, your bonds, your mutual funds in your trust, if you go down to your friendly bank or financial advisor and say, I want to fund my living trust with my IRA, they're going to stop you, okay? Because if you take a $100,000 IRA and put that into your living trust, you have just withdrawn $100,000 from your retirement account. That IRA money is held by a custodian. You get the benefit of that $100,000 IRA, but that IRA is held by a third party. It's held by a custodian, not you. Even though it's your IRA, it's held by that custodian, and taxes, typically if it's not a Roth, taxes have not yet been paid. Now, it becomes immediately taxable. You may also be subjecting yourself to early withdrawal penalties. Now, Secure Act 2.0 changed that. We're going to have a webinar on that, but it might lead to potential penalties in addition to the income tax. And so how do you deal with retirement accounts? Well, you name a beneficiary. So what you do is you say, and if you don't know who your beneficiary is, reach out to the company. Sometimes it's included in your statement or it's provided to you just as kind of a refresher. But you can also reach out to your financial advisor or institution and say, hey, I have this $100,000 account, this IRA account. If I die, who gets this account? Because it doesn't matter what your living trust says. Okay, let me say that again. It does not matter what your living trust says. It matters what the records at the institution say, because that IRA is held by that institution, by a custodian, right? Literally, they're holding that money. And the person who shows up with the death certificate, whose name matches the beneficiary, that person's going to get the money. That person's going to get the IRA, not what your living trust says. So if you say in your living trust, I leave my $100,000 IRA to my daughter, you better change your beneficiary designation, right? That's not where you want to put that provision in your living trust. You want to make sure that's handled at the institution level. So some people say, well, Jim, can I name my living trust as beneficiary, right? Everything else, everything else is going in the trust. Can I name my living trust as beneficiary? Now, I would say you can. In the vast majority of circumstances, that is not the best way to do it for most people. Now, I know that sounds really qualified, but I suppose there are certain circumstances where it might make sense on some level to have those IRA proceeds flow through your trust. And what I'm thinking of is if you set up a charitable trust at your death and stretch out those payments over a 20-year period. It's one way to get around this Secure Act 2.0 10-year RMD period. We'll talk about that. But I would say in our practice, in our firm, we typically name individual people. So this is human beings with a heartbeat. So what that means is a human has to inherit the IRA, and that human has to be alive, meaning they have to have a heartbeat in order to have the maximum deferral period for required minimum distribution. So what am I saying? As we all know, currently it's 72 for most accounts. You have a required minimum distribution. You hit a certain age, money's got to come out of the account, you got to pay tax. Once the IRA is inherited, a different RMD schedule exists for the people who inherit the IRA. Now, this is not one size fits all. In the vast majority of cases, it is going to be a period of 10 years, right? If it's done correctly, the maximum period is 10 years. If it's done incorrectly, it can be 5 years or even a shorter period of time, okay? Meaning if you have $1 million in an IRA, would you rather have that $1 million be distributed this year or 10 years from now? I'll take 10 years from now, right? Because that money that would otherwise go in taxes is earning money. And also the tax brackets get adjusted for inflation every year. So you're better off on a tax deferral. You're always better off deferring taxes, right? Because you're going to be paying it at lower rates. So again, once this IRA is inherited, a different distribution schedule kicks in. So if I'm retired and I'm 72, I have a distribution, a required minimum distribution schedule. But if I inherit an IRA from my father, I have this other IRA. I don't merge that into my IRA. I don't roll that over to my IRA. It stays its own separate account. I'm the beneficiary. It's in my name. And I have a different RMD schedule than I do if it's my own IRA. So what can you do? You can name an IRA legacy trust as a beneficiary of a retirement account. Now, this is a purpose-built trust. This is not a living trust. This is to hold that IRA that's being inherited, and it's basically putting a wrapper around it. Now, why do we do this? So, well, you might have a loved one with special needs, right? And it really does make sense for a lot of reasons, because they can actually stretch that out for their whole lifetime. So, a very powerful tax deferral strategy. Or minor children, right? People who maybe aren't responsible. Maybe if it's a large estate, or the person that you're leaving an IRA to has a large estate. So you leave your IRA to your son, who's very wealthy. Well, when he dies, that IRA he's inherited is included in his estate. So we can use a trust to address some very narrow situations. Many of our clients just like the idea of having a trust receive the IRA, because now you've got a plan, because a lot of these IRAs are really big. People have $1 million, $10 million IRAs. It's a lot of money just to put someone's name on it. There's absolutely no creditor protection, by the way. If you inherit an IRA, the Supreme Court ruled 9-0, zero creditor protection. All right. Who pays the tax? If my creditor takes $1 million IRA that I own, that I've inherited, do I pay the tax on that? It's actually an unresolved question. So my creditor may get the million, and I have to pay the tax. So for those reasons, IRA Legacy Trust is a great idea. So Hal and Wanda have $1 million home, $1 million in savings, and $1 million in IRAs. They create and keep updated their revocable living trust. And that includes wills, powers of attorney for property and healthcare, HIPAA authorization, and deeds transferring title to their trust. And they name each other as beneficiary of the IRA. And then they name as second beneficiary their IRA Legacy Trust. So the great thing is, that $1 million is protected from the kids' creditors if they have any. And divorce, by the way, is the single biggest threat, in my view, to inheritances. That really strengthens your argument that it maintained as separate property if it's in a trust. And there are some potential tax planning advantages. Could that trust be cited in Nevada and perhaps delay some payment of California tax? Yes. Can you use tax bracket arbitrage and distribute some to individuals, but keep some in the trust and pick up on those differential tax brackets? Yes. So there's a lot of planning you can do with the trust. I would say the break even on that, though, you probably need $500,000 or $1 million in your IRA, really, before we're starting to look at the IRA Legacy Trust. So the takeaway, everyone, wealthy or not, should consider estate planning. This is very, very important. Who wants to go to probate? It's crazy, right? Why would you put your creditors ahead of your own family? Nuts. Just, get a living trust, get it funded. It makes sense for Hal and Wanda. So taking back to the example, to seek out a savvy lawyer, an expert to help guide them through the complexities, really, of their unique situation. I will tell you, I did not appreciate this when I was a younger lawyer. Every situation is different. This is not one size fits all. There are so many nuances in estate planning that, frankly, a lesser experienced attorney or someone who's not a specialist, they simply just don't see them. It's kind of like putting on, it's kind of like looking at a microscope or through a telescope. Is you see a lot more as a specialist, someone with experience, that maybe other people aren't going to see. And certainly, if you're trying to do this on your own online, you're really not going to see it. So not really a good idea. If Hal and Wanda ignore the essential elements of estate planning, it puts their entire accumulated wealth at risk to predators, right? Conservatorship, probate. We're going to talk about conservatorship next week, and creditors and divorce. So if their kids get divorced, they could lose half of the inheritance that went to the child could end up going in a divorce case, could end up going to the divorcing spouse. I would say, as a general plan, review your estate plan every 3 years and on your own, maybe every year on your own, with an attorney every 3 years. So every year, take a look at your estate plan, maybe around Thanksgiving. We're coming up on the holidays here. So, once Halloween hits, it seems like, New Year's is about a week later. So I know it's a busy time for a lot of people, but it's actually a really good time to look at your estate plan. Many people get together with their family. And so this holiday season, which is now upon us, it's going to go quickly. especially if there's been a birth, death, divorce, or a bankruptcy, right? Because sometimes a bankruptcy trustee can make an order with respect to a future inheritance. So, you really have to be careful with that. So how do you educate yourself? Well, the book, Savvy Estate Planning, What You Need to Know Before You Talk to the Right Lawyer. That's in our second edition with updates from the Secure Act, which changed retirement accounts, as well as our YouTube page. So if you're watching this on YouTube, you're already there. If you've never been to our YouTube page, check it out. And also our webpage. So a lot of material, a lot of helpful material. And we have offices in Northern and Southern California. I happen to be in one of our Northern California locations today. But we are close to many, many people throughout the state of California. We also meet on Zoom. A lot of my meetings, frankly, are on Zoom, and a lot of our client meetings are as well. Next week, incapacity planning. This is savvy planning, really for the inevitable. Why do I say the inevitable? Because most people have a period of incapacity before death. Many people have a period of incapacity, then get better. Well, what happens? Like incapacity, what's going on here? And this is really, when the parents become the child and the child become the parents, when that role switch happens. So that is coming up September 21. And if you're watching this on YouTube, you might have already seen this one if you're past September 21, 2023. So for those of you watching it live, that is next week. Subscribe to our YouTube channel, click the bell, and you'll be alerted when new content comes up. So we'll take some questions now. And if you're watching this on YouTube, just keep watching, because magically another video is going to pop up and I'm going to keep talking.